G'day everyone. Well, tonight we're going to have a little bit of a chit-chat interview with our friend Brent and see what little magical things he has to come up with to help those all out there studying legal land. You know, we're not going to go into jurisdictional arguments. Dilip, all right, you may think it's all about you, mate. I'm not going to go into that, but for tonight, we're having a Dilip Rupa free evening.
Hello.
Hello. Oh, hi. Sorry.
Hello, can you hear me?
Yeah, I can. Hang on. Let me just pause that. How the hell are you?
Yeah, not too bad, not too bad. Hopefully my computer doesn't go too slow. I might have to shut half the other crap down I got going.
You want me to bring up on page, mate? Just drop it in the PM. I can bring it up.
Why is the volume so low?
Oh, hang on. Is that better?
Oh, that's better. I'm sure that can't be right with my speakers because they're stereo speakers.
No, I turned my had my gain down on the mic.
Right. Okay. Yeah, that'll do it. That'll do it. Yeah. Been having an interesting day. I started getting through the first 23 pages of that 197-page document, but it was screwing with my head a bit because on the Adobe Reader I found how to get it to read it out loud to you.
All right.
But my eyes were reading faster than what the actual person was speaking, so it was sort of doing my head in.
Should be able to speed up the speed of the reading, no?
But it's just it's been an interesting read so far, and to find that like the first 23 pages basically go into the Crown liability and how that Crown liability works within the public sector, and how each person within the Crown entity organisations are accountable through Crown. So it's been an interesting read so far in those first few pages, but yeah.
But and who is the Crown? You know.
Yes. So the Crown is the Queen herself. The Crown is the judiciary. Just the judiciary. Anybody who works within the public sector, all of the ministers, the Prime Minister. And they don't have the level of immunity that everybody thinks they do.
What about lawyers?
No.
Lawyers
come under Crown, but the level of, like, everybody that's associated with Crown, including officers of the court being lawyers, how everybody thinks that they have like this diplomatic immunity, the immunity is limited to the liability. If you make them liable.
Did we put it in the drive here somewhere?
Yeah, I did put it in the drive. I think it's called, hold on, I'll tell you the name of it. I'll go to my one, because I've got it in the court documents part, court forms. Crown liability and judicial immunity.
It's in the main folder, is it? Oh, yeah, got it right here.
So yeah, I haven't read the whole thing. I've got like 23 pages in, but the first like 5 pages is all the index and everything.
Right.
But you know, it's quite an interesting read in the fact that I always thought the Magna Carta was different to the Bill of Rights, but going by this document, it's the 1688 Bill of Rights, pretty much Magna Carta, is today's 1990 Bill of Rights.
Right. It's just been re-legislated.
It's been, how could you put it? It's been put in more layman's terms than how they did back in those days.
Yeah, codified.
Yeah,
the Bill of Rights Act, Beijing case.
Yeah. But yeah, like I said, I've only got through, like, you know, I've been past all of that part, and I think I've got down to number 34 in the paragraphs. And it's like, yeah, okay, I see where things are coming from now.
And it basically discusses
all of the liabilities. It discusses about as you can see there on the middle of the page you've got up. It talks about judicial immunity and stuff like that. But the judicial immunity is not in it's in regards to just particular statutory provisions and stuff like that. So it's where we're led to believe that a judge has full-on immunity. That is not the case if they have not acted within the powers and functions of their judicial role. So if they've missed a procedural step, they are able to be civilly or criminally prosecuted in regards to it.
Because they're not doing their procedural things correctly. So it's not a matter of their conduct, it's a matter of...
It does become a matter of conduct, because the conduct is like the two complaints, like I was telling you I was doing 2 complaints. I've just finished those today, so the next part is to move on to the other civil proceedings bit. But the starting to read through this document gave me an understanding that when you look at the conduct of a judge, it's to do with the powers and functions of the judiciary. So the powers are to do with the statutes and the legislation, and the functions, the 4 functions of a judge, are to do with the protection of the individual, any individual that does a criminal act. Number 3 is being able to decide on the rehabilitation process for that individual, and number 4 is the speed and efficacy of the court proceedings. So, in a family court proceedings, my understanding of it is that number 1 and number 4 apply, because the particular individual needs protecting, and the court needs to do it with speed and efficacy. However, that speed and efficacy, I'm wondering where it got to, because I'm sure we've got the Mini instead of the V8.
Yeah, well, we all know what happened to that. The thing called legal aid came in, and now lawyers just milk it and keep people on it for years and years.
Yes, but when you get judges that decide that just because you're appealing something, they're going to stall the proceedings and not go any further on any application, that really cannot be blamed on the lawyers. Gosh. But then if the lawyers do reading through it all and having a good look at the Lawyers and Conveyances Act of the section you were talking about, 272, again, we're all led to believe that, okay, if the lawyer does something wrong, that they don't have any liability. But it really depends on the fact of whether that liability, or what they did, liability is still achievable in regards to the fact that at the end of the section, it quite clearly states, unless they've done it in bad faith. And you can prove to the satisfaction of the court that they have done so. Yeah. And in doing so, you could complain to the Law Society, but all you're going to get is the lawyer with a little slap on the hand. So rather than do that, the obvious option.
Or if there is like a monetary fine or something going on to the lawyer, that lawyer generally has to pay that to the New Zealand Law Society and not the person they've actually done wrong to. That person still gets nothing.
Yeah, exactly. And that's why my way of looking at these situations is, rather than write the complaint to the Law Society, but as the bottom where you've highlighted states, if it's done in bad faith, bring a civil proceedings against them. Because realistically, people in these authority positions don't care, because they've got these provisions within the Acts, and they look at it from the point of view, what, are you going to take me on? I'm a lawyer. Yeah. Well, it doesn't matter whether they're a lawyer or a judge or what position they hold. The fact is, if they did it in bad faith, or if it's a judge and they didn't follow those procedural steps, they have lost their immunity in regards to that particular part of the proceeding, and therefore accountable.
Are you listening, Timothy? Tim?
Yeah. So it's one of those things where, like I said, I've only got through the first 23 pages, but it's one of those things where I understand now why people in the positions of the law and stuff like that, why it does their head in, but it does make it a little bit easier when, like I won't mention the individual, but I spoke to a lady that gave me clarification in regards to a couple of things within law, and that made my complaints completely different today.
Completely different. Of it, doesn't it?
Oh, yes. I mean, like, I honestly think that if everybody understood the powers and functions of a judge, they would completely change how they wanted their lawyer to deal with their case.
And what were you saying about different types of QCs as well? I found that.
Well, yeah, there's from my understanding of speaking to a certain lady, there's the QCs like the Queen's Councils. Then there's the ones that are like the royal that are over have like royal oversight, like the Queen's oversight, and then there's the ones that have the royal family oversight. That's my understanding from the talk I had. And given it came from one that is actually a QC, I've got no reason to doubt it.
Yeah. So which is the more, I suppose, higher?
So it goes QC, and then it goes the QC answerable to the Queen, then the QC answerable to the royal family.
So the royal family has higher power than the Queen. I suppose they'd have to, wouldn't they, if the Queenie drops off?
Well, you would think it would be the other way around, but considering that the royal family answers to the Queen.
Yeah, exactly.
So that's something that I don't understand.
Head of the family sort of thing as well, isn't it?
Well, yeah, it's one of those things where when you have a discussion like that, all of a sudden the whole perspective of any case changes, because as it was explained to me, those two particular, as they say, a lot of the courts will say you haven't followed the two-step process. And that's what they mean by the two-step process is did the judge operate within the functions that they can, the four functions? And if so, did they follow the statutory legislation in the procedural steps that have to be taken to get to the final outcome? But the interesting thing was, reading up on it all, you'd think it goes District Court, High Court, Court of Appeal, Supreme Court, and that would be the power levels. Sure. But to find out that it actually wasn't was quite an amazing point. The highest, the court with the highest power is the High Court, because they have the inherent jurisdiction as well. And so when you go to the district or family court for any type of civil proceedings, it's good to know that the judges sitting in the district or family court have statutory jurisdiction only. And so they don't possess the inherent jurisdiction, which is the jurisdiction, from my understanding, where if a judge in the High Court doesn't see there being something in law that can help him determine that case, he's able to change the law on the spot to make the determination.
Oh, cool. Yeah, they can.
So it's been an interesting, I think in the last, was it yesterday? No, the day before. In 15 minutes, I think I learned more than what I learned in a year.
Yeah. Amazing.
But it's not one of those things you want to learn.
But it changes your whole perspective, two-stepping.
Well, yeah, it completely changes the whole perspective, because when you're thinking about each part, like if you apply it to if you're looking at a document that you're saying, okay, this is my evidence, if you apply the two-step process to it, it might not be evidence. Because like the lady I spoke to, she was telling me that she did have one case that had nearly a couple of thousand pages of evidence that her client brought forward. But by the time she got through it all, it was down to 10 pages.
Wow.
And she said the rest of it really didn't count to the case, because she said she said to me, when they're talking about merits of a case, you're looking at the two-step process for the merits. You can have all of that evidence, but if you apply the two-step process and it doesn't look like it's going to help you, it's not evidence.
Yeah, of course. It's whether it's,
and I was like, okay, yeah, so
or not, isn't it?
Yeah, I mean, it's one of those things where when you're learning those sorts of things, you think to yourself, okay, well, it's not something I wanted to know, but it's good for people like yourself and myself, where if you get that type of information, share it around, because hey, it helps everybody else.
Yeah, and there's going to be a lot of self-representing litigants out there, and
yeah,
wasn't it the difference of being a self-representing litigant or someone with a McKenzie friend versus having a lawyer?
Yeah, and it was stated to me that, okay, normally what you'll find out if you become a self-litigant is that the judiciary who was dealing with the case at the time, because it's a self-litigant, will add 2 to 3 years to that journey, just simply by even if you have all of the information. No, it's not right, because you shouldn't be litigating yourself. People have studied 4 or 5 years to be able to represent you. But how does that work when you have the right to natural justice under 27.1 and you can represent yourself under New Zealand law?
Exactly.
So your rights get taken away from you under New Zealand law again.
And you're not held to the same standard as the lawyer is in that courtroom.
That's right, because you're not an officer of the court. So therefore the court can't expect you to understand the etiquette and processes of the court. But when I suppose after 2 or 3 years, what it comes down to is, as she'd put it to me, is that should wear the person down enough to the point they don't want to keep self-representing, so they give up.
It's basically.
But then you get stubborn buggers like us that go, I don't think so.
Yeah, I've always said tenacity has to kick in there at some stage.
Oh yeah, and I mean it's sort of one of those things where throughout my whole life, even no matter what it was, if I couldn't figure something out, I would keep trying until I could get it figured out.
Exactly. Don't let it.
And so yeah, to learn all of that, and into that document you brought up before, it goes into documents in 1908 and 1688 and the 1950 Judicial Act.
Yeah.
So it's like I can see it's going to be a long read, but it's one of those ones where, I reckon you got to take it in bit by bit, because if you try to take it all in together, your head's going to swell and go wrong.
Yeah. No, fair enough too. Decisions, so they go through. Looks quite.
But it is a very, very interesting read in regards to unreasonable search and stuff like that. But I mean,
principles thing. Are they trying to say judges have principles? Are you kidding me?
In the acts, they have the principles and the powers. However, does the judiciary apply them? In my view, not very often. And if they do, it's not in your favour.
The Act develops and Protection of the Citizen, Chapter 29 of the Magna Carta, 1297.
Yeah. As you can see, it goes right back, eh? But my understanding, and I could be wrong, but my understanding is the Magna Carta is today's Bill of Rights.
Yeah.
But like I said, I haven't read the whole thing. I've got down to, I think it's about 34 or 35. And it's just, you get to see how, through this document, how everybody has been led to believe that you can, if you try to take on the state, you can't win. But if you apply that two-step process to everything, then it's not a case of you can't win. It's a case of, did they follow the procedural steps and what they were doing? And that goes for any public servant in the registry. So the registrars, all of the court people, they're all still bound by the same thing.
Right.
So it's a very interesting read so far. Like I said, I think I've got about another 173 pages to go.
Yeah, the likely con. Okay, cool. I'm going to put it on an auto reader and then just play it while I'm asleep for a few nights.
Sure, do it subconsciously, eh?
Yeah, that's it. What was the other thing you wanted me to have a look at? Oh, that's right. It was where are we?
You might have to remind me, because I've been doing quite a bit of things today with the complaints and stuff like that.
Commissioner, Select Committee. Remember this?
Oh yes, that thing. Oh my gosh. I honestly believe it would be helpful if the people that are on these things, it's referencing Section 78 of the OTHO Act, and when you've got a, we had the Minister for Children on there, and they're all
down the bottom left.
Yeah, and I mean, when someone says that someone's got a gripe about, has having a grizzle about how the new amendment bill and that is, that's not the kind of comment you would expect was from someone in an authoritative position.
Yeah.
So
that's
well, yeah, I mean,
a parent would talk to a child, really, isn't it?
Well, it is, and it's the fact that when it comes down to it, if he thinks that other officials are having a grizzle about it, how appropriate is the person for the position if they're going to turn around and say, don't grizzle about care and protection of a child? Well, who wouldn't grizzle about that? Especially if the amending bill is they see issues with it.
Especially if
the only
grizzle's justified.
Well, yeah, I mean, if the grizzle's justified, then okay, fair enough. But I mean, he could have used, could have chosen wiser words. But you know, listening to that particular thing, and then at the end, I think it's, I can't remember the judge's name, but she's the children's commissioner now, and going by the she was talking about how a section 78, the lady, where is it? I can't. I think it was that Karen Chow. I think it was. I'm not positive. One of them asked her in regards to section 18B of the Act being repealed, and she was saying that she believes section 78 should stay there, and that 18B should be repealed. I think it was 18B. But the reality is, it's 18A that has subsequent child. 18B is in regards to who, what kind of a parent, you know, what things the parent has done that would qualify them to be have the subsequent child removed under section 18A.
Let's have a look, shall we? He's talking about Oranga Tamariki.
Yeah, like 18A down there, where it says, yeah, the assessment of the subsequent child. Go down a bit further. Yep, down there.
See, that's even deceptive the way they have that, isn't it? I mean, 18 AAA, then 18, then ABCD.
Yep.
What the fuck?
Yeah, and then if you go to 18B, 18B describes the person for the section in regards to subsequent child.
Assessment of parent of subsequent child, right? And we go to B. Person described in this section.
Yeah. So a person within that section, it's mainly to do with murder, manslaughter, and child infanticide, or a child, young person who's been in the care of a person who's basically someone who's seriously hurt a child.
Murder, manslaughter, infanticide, or the death of a child. Yeah.
Yeah. And so when it comes down to it, I'm not positive, but I think she was saying about repealing that section. So that doesn't help in regards to the subsequent child, because you've still got the subsequent child section.
Yeah,
this is just a different, that's just a person described in the section.
Yeah, 18B just describes the person from 18A, but getting rid of the description. So what do they want to do?
That's right.
Description of the person.
Well, and that's exactly it. So when it comes down to it, even if you took out 18B, they can still go 18A2.
A2, where's, oh yeah, A2, that one.
Yeah, so you can, there is still other subsections in there. Like, I mean, if they really wanted to uplift the child based on safety, they could also go section 39 for a place of safety warrant. You know, they've made it sound like there's only certain provisions within the Act that allow them to uplift, and section 78 being one of them. But just down below there, we've got 39, 40, 42, you've got all the warrants there to uplift the child.
Yeah, warrants to remove child or young person, person executing, oh, that's repealed. Search without warrant.
So your section 30, 39, 40, 41, 42, or 41's been repealed, but you're searching without a warrant, they can come into your house and look for the child.
Wow, it's crazy.
So it's what I didn't understand really is how the judge, that's the Children's Commissioner now, stated that under section 78 you can come back to the court within 14 days to have your case heard. Now, and she said, you know, that's how it's supposed to happen. Now, I agree with that comment. However, the section 78 going before the court is not supposed to go until such time as the FGC has been held. The FGC has got to be held first.
I'm just wondering if you know roughly what time that was in, mate. Now let's listen to what she has to say. And what qualifications does she have, by the way?
She's a judge. She was the
talking about natural justice here. Here we go.
There you go.
I see the child commissioner is, I'm guessing, in the room. Hang on.
Yeah.
So we have your submission. Thank you very much, Judd.
just yell out if you need me to pause it.
Yep.
Coming before us. Thank you for your time with us today. We have 10 minutes. You may have noticed that we have lots of questions and we're running out of time to ask those questions. So if you'd like to leave some time, we'd greatly appreciate it. Thank you for your time today. We're in your hands.
Tēnā koe te tiamana me ngā memo o tēnei committee. Tēnā koutou I runga I te kaupapa o te rānei. So greetings to you all and thank you for hearing us. I've listened to a few of the previous submitters and I know you've read our submissions and time is short. So I really wanted to speak to you today as Commissioner, but based on my experience both as a judge, a lawyer and also a mother. So obviously we very much support the repeal, particularly of the Section 18 D provisions. Is what we call the subsequent children provisions. In the courtroom, in that care and protection space in particular, I never once, as a lawyer or a judge, came across whānau that didn't want their child, that didn't love their child. They did. It's just that in that space and time, they were not capable of caring for them. And I always thought that what we needed to do was to really get very intensive wraparound services for that whānau at that time and help them through. And that is what's needed. What this law did, however, was to really drive a wedge in whānau, and when it came into practice as a judge, I thought it was quite astonishing because it seemed to me to be draconian. It seemed to breach the principles of natural justice and very paternalistic.
Pause.
You shouldn't be. But she's only
So
talking about descriptions 18B through D.
that's right. So where is the part for 18A, which is the subsequent child part of the Act?
The one that actually has the power.
That's right. So let's remove away all of the other parts that justify us doing it and just go ahead and remove the child anyway.
In court declining to get. So all of those are actions after the first one has to happen. My God.
And the important part to note in that they're not talking about there so far is this is based on a social worker putting the evidence forward. And if that evidence, like how she is saying, getting the wraparound services around the whānau and the whānau is not capable of looking after the child, that example is based on paperwork that is put before them and making a decision off of that paperwork. So if you've got a social worker working on it,
social workers might be lying, and then you've got.
That's right. So if you've got I suppose the way to put it is, if you've got an affidavit that was supplied in bad faith, you have no chance of keeping your child because the judge has to go by what's placed in front of them. And if that contains, as they put it in law, falsities, false information, then you don't really have a chance of keeping your child even if you've made changes.
Oh, what were you saying about bad faith? Lawyers. Bad faith, so you can civilly prosecute.
So under the 272 of that Lawyers and Conveyancing Act, when you read down the bottom of it, it says that like the liability of a lawyer, there is no liability on them by putting the documents forward and stuff like that, except and unless they did it in bad faith. And bad faith would be, okay, they know that what you're putting within your affidavit is incorrect information, yet they still filed it.
Really?
Yeah. So I mean, like, if they can't honestly say, I didn't know my client did that, how could they not know when they filed the document?
Yeah. That was saying, in other words, they're supposed to proofread and look at everything they're filing.
Yeah, I mean, it's like, okay, self-representing. You make sure that you put forward the correct information. Although, in my experience of self-representing in the last year and a half, and this will sound very bad, but being honest to the court and supplying them with the right information gets you called out for slagging off the other parties.
Yeah, it's hindered you. being honest and forthcoming with all of the facts and information has done nothing but make the judge bias and say you're slagging off the other parties in Crown law.
Exactly. And then what it comes down to after the last couple of days of finding out the other information is that the reality is, okay, there's liability there now.
Yeah, yeah.
But, you know, I just thought I'd get you to pause it there, because what she's had to say in regards to those matters is dependent on the information put before the court. So when they're saying that, when she's saying that the whānau can't look after the child, that decision, in my view, that statement is made and based on the fact of the information that came before them. So if that information was incorrect, then the decision is still going to be made to uplift the child, even though there was not. This is what I say to people in regards to, it doesn't make every parent bad.
Yeah, well, I think the difference is they're acting on information that's put before them, not evidence and facts that are put before them.
Well, when you consider, like she's saying,
can be anything.
well, yes, but like she's saying in regards to that, the main part that is missing that the committee hasn't heard is, okay, if you take any of that information and you put it before a court, Section 71 of the OT Act says no evidence is required to be able to be put to the court to make the decision to uplift the child.
Section
71. Court may make a cure of petition in absence of proof.
Jesus.
So if there's absence of proof, that means that the parent might not have done a damn thing wrong, but because they put a affidavit in front of them, the judge does, like, the important part to note with affidavits and evidence, okay, is when your child is uplifted and you think the judge has read what's in there, that's not the case at all. None of the evidence or paperwork you put forward, as we discovered, gets heard or looked at until the hearing, when you draw on it through your annex numbers. Before that, no judge has read it.
Yeah, yeah. And
so even if
you'd expect them to have read the submissions, but they haven't. In fact,
yep.
I've struck judges turn around and say, no, I haven't read any of the submissions because I didn't want to be swayed one way or the other.
Mm-hmm. But the problem with in the family court, and when it comes to uplifting children, is when someone applies without notice, it's the without notice system was originally brought in what they call the what's it called? The e-duty system. So I think it was Judge Sean Elias that brought it in, and she wanted it taken out. It was supposed to go out in February 2020, but it's still there today. And the reason that she wanted it taken back out again is because the reason that it was implemented was for very, very urgent cases that involved a lot of violence to a child, which is understandable. But as she said, the judges on the e-duty system, because normally if you're not in COVID, like we're in COVID at the moment, but if you're in a normal year, there is 2 judges that get selected daily that are on the e-duty system. And they do electronically the without notice applications. The problem you get is you get judges on there that go click, 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 and don't look at anything. And so therefore the child just got uplifted, but the evidence may not be pertinent enough to allow for that uplift.
So they're not, quite frankly, doing their functions or powers correctly.
That's right, but they fall back on Section 71 because the court can make the decision in the absence of proof or responsibility for neglect. So
that's a little get out of jail free card. Quite
that one there, I look at it as, after the last couple of days, as being a procedural step you can take to not take the procedural steps. So it's really just a let's go around the merry-go-round type thing.
Dweeb. Yeah, that's the one. Yeah.
Yeah. So when it comes down to it, you can put whatever you want before the court in a without notice application, and they like even in an on notice application, and like people say it takes 4 years. I was reading on one dad's group where it said it takes 4 years to get to a hearing. Why does it take 4 years to get to a hearing? Because you don't know that under Section 200, especially if it's under the OT Act. Under Section 200 of the OT Act, it must go to a hearing within 60 days of the application being filed.
bet you most people don't know that.
Yeah, and I mean, I put that in a couple of memorandums, but you know, the judges just think that they can ignore that. So Section 200 tells you that it says there no later than 60 days. It's at the bottom line there, after the application is filed in the court.
Absolutely.
So realistically, the people that go on for, where their case goes on for months and months and months and months, they're just not aware that, okay, from the time you file that application, the court has 60 days from that time, which is why when we filed our latest application, in a memorandum, I reminded the court that 10 days had passed and that there was only 50 to go.
Yeah. You're keeping a track of the countdown, even though they might not give a toss.
That's right. And like when it comes down to it, if they're dragging your case out, I always forget the subsection, but under Rule 132 of the Family Court Rules, you can apply to have that time decreased to like 21 days to be able to have it heard. Family Court Rules, yeah, Rule 132. I can never remember I know it's subsection 2 and subsection 3, but I can never remember which way around it goes. I always end up having to refer to it. But one talks about the increase of time. The other one talks about the decreasing of the time. And the interesting
is reducing.
Okay, so if you read it, you've got two. I think it's 2A goes in front of a judge for it. 2B goes in front of a registrar, and then you get 3A goes in front of a judge. 3B goes in front of a registrar. So what happens is a lot of the time you'll get pushback from the registrar. They don't want to file it in the memorandum. So the easy fix for that is you just turn around and if whichever one you're applying for, you make sure it's either 2A or 3A. And then when they say, no, that's not a possibility, can you read your own rules? It needs to go in front of a judge, please.
Yeah.
And then you normally get the response, I'm able to decide on that. You're a registrar, not a judge. Please put it in front of the judge.
Yeah, because I would have thought A comes before B usually.
Yeah.
Call me.
But it's one of those things where you can turn around and like, and the unusual one we had was when we put our application forward, the last one, it wasn't actually us that applied for a reduction in time. It was actually the judge who made the reduction in time for the respondent to reply.
Yeah, he cut their time short, didn't he?
Mm-hmm. So that was an interesting one. But yeah, it's just those when it comes to the select committee part, it's just a case of looking at those sorts of things. If you're going to mention about 18B and 18A, why not be informative and let them know that 71 says that when they put it in front of the judge, they require no proof.
Yeah, exactly.
And to me, the section that should be repealed is 71. How can you get accountability on it if 71 is there and no evidence is before the court? But even in doing so, the other part that hasn't been mentioned there is that from the time the application has been made, if it goes in without notice, the judge decides that they are going to hear it, because she was talking about on the section 78 that she from memory it was 14 days afterwards. Like I said, the FGC normally has to be held before they can apply for an order.
Section 78.
And so 78 is 78.1 is interim custody. But to make that application for the interim custody, they normally have to be able to turn around and hold an FGC, because the FGC is needed to be able to under section 68 to be able to determine that the child is in need of care and protection. And if you go to a family group conference and you get one person at that family group conference who disagrees that the child is in need of care and protection, that changes the ball game altogether, because they can still make the application, but in the meantime, the child's going to stay with the parent until such time as the 78 application can be heard in the court. So you actually get a chance to defend yourself on something that's more than likely, in a lot of cases, is pure rubbish that's been put to the court. And when they apply for these sorts of things, they're sort of relying on the fact that you don't get a chance to defend yourself or your child.
So before the interim custody, if one or whoever of the parties at a family group conference doesn't agree that the child's in need of care and protection, the parent keeps the child.
Well, what happens is the FGC, if there's no agreement to care and protection, there is care and protection that, needed, that is at that stage, that's the time when the FGC must be ended. Because if there's no agreement to care and protection, you can't go into what they call the family time part of it. Well, sometimes they will, it depends on how they run them sometimes, because they run it where they've got the family time and the family's agreeing with this care and protection. But as long as you get one person, like I participated in the FGC to help a lady, and it did not get to the family time. It did not get past the professionals. Why? Because at any stage of an FGC, you can state, I'm sorry, I do not have care and protection concerns in regards to the child, if you're the parent, or if you're anyone else there, you can say, I do not see any care and protection need for that child. Once that happens, the FGC is over. And
Good.
like, and the one that I sat in, I ended up having to ask to speak to the FGC coordinator. She got on the phone, and then she took the phone outside, she spoke to me, and I said to her, look, the lady's already said 3 times, she doesn't want us to carry on. She doesn't agree that the children need care and protection. And she said, yes, but we need to listen to the professionals. I said, no, what you're supposed to do is if you get non-agreement from any person at any time throughout the FGC, that FGC must be ended. So all she said to me was, I'll go back in and ask her, and if she says the same thing again, we will end with the karaki. I said, that's fine. So she went back in, she asked the mother, she said, I've told you 3 times I don't want this to carry on. That was it, it was finished.
Nice.
But you know, the problem is people feel pressured into, like when we had our FGC, we were pressured into the fact of you must agree, otherwise they'll take the child, take the child from you.
Yeah.
After the FGC coordinator having stated baby will remain with mum.
Yeah. Yeah.
You know, but when you've, I mean, like that right there, there's liability for the lawyer right there. You know, she's given false information and stating to us that the child will be taken straight away. And so what happens after that is that then it goes back to court. That's what the requirement is. It's got to go back to the court because the FGC didn't work and you couldn't get an agreement. Now, the good part about non-agreement, and like I notice on a lot of the pages on Facebook, they always say just agree to it so you can get a plan in place. The problem with agreeing, okay, and I can say this firsthand because we have been told it by the court ourselves.
Yeah.
When we stated that we agreed under duress, the statement made was, but you agreed.
Yeah. Doesn't matter. They don't give a shit about
So
it.
therefore, it doesn't matter whether it was done under duress or not. The safest thing a parent or a grandparent or anyone in the room can do is go, no, we do not agree. Unless, of course, the child is, being physically harmed and that, and you know it, then yes, a plan needs to be sorted. But I honestly believe that out of probably 100 cases that would go through it, you'd probably find 97, 98 of those cases aren't actually getting abused. It's just a case of they've got a complaint and they try and make it as worse as possible so they can uplift the child.
Justify their existence. Yeah.
That's exactly what it comes down to, in my view, because I mean, like I will admit I've helped quite a few people now with their cases, and none of them come under the abuse side of things. None of them.
It's more the abusive process.
It is the abusive process. It's the social workers. If you look at the OT Act, it's the social workers abusing the procedural steps within the legislation that they have to use.
Is there a section there for that?
Well, okay, the sections that they will use to bring a child into care, okay, is section 14 and 14AA.
Yeah.
Because they must be able to define how the child's in need of care and protection. Now, at the top there, you've got 14.1a, okay, 1, and then you've got 1 and 2 under it. So those two there, they are needed to bring in 14AA. And 14AA is where they turn around and state that the child's circumstances could be neglect or stuff like that as well. and like up the top there, it'll say, there it says they're abused, whether physically, emotionally, and sexually, deprived or ill-treated and neglected. Okay, but what they will always do to make it the constitute, like even in the Act, you've got the word serious harm there all the time. But when you look at the definitions or interpretations, there is no serious harm. What they define as serious harm, as we found out, is if you go down to 3, down the bottom there, it says there, 3B, 2 or more incidences that are taken on their own would not be serious enough to constitute serious harm, but the cumulative effect of which is serious enough to cause serious harm. So they use 3B and 3C, and what they do, okay, you can have something as small as, how do I put it? Say you tap your hand on tap the hand of your child,
Yeah.
right? And you do that more than once. You've just caused cumulative harm. So now you've got a care and protection case with them involved, and all the courts care about is Section 14AA3B says you harmed your child in a serious way.
Wow. And serious is just more than one smack on the hand.
Yep, it can be simply a case of, they've even, like from a couple of cases I've heard about, they've constituted the fact that 2 or more incidences yelling at the child.
Yeah. Yeah,
When they say yelling, they're more, it's more a case of, it's like a parent going, go to your room. I said go to your room. 2 or more circumstances. But because the neighbours heard it, it's cumulative harm.
Yeah. It's crazy.
But, here's the interesting thing. Reverse it around and have a child in their care where the child's been harmed multiple times, and
But,
all of a sudden the court does not want to hear 14AA3B.
Yeah. Like, look at yours. There was, what, 7
Yeah.
documented times where it happened, and still.
Yep, and when I listed that as cumulative harm, no, that wasn't good enough. The fact is, when it comes down to it, sometimes you'll actually find that where they say the child is at harm and needs care and protection, the unfortunate side is, yes, that's true, but it's from OT.
Yeah, they're the one.
It's not actually from the parent, and it's really weird when the harm happens to the child outside of the parent's care.
And they're
But
interfering. They're also screwing up the ICCPR by interfering with your family life and family structure without good.
That's right. And you bring all of that up and they just go, too bad. But if the child's with you, they're relevant facts to their procedures.
Yeah.
So it's one of those things, but yeah. But that select committee, that really sort of, when it came down to her talking about the Section 78 and what you can do after the 78.
Yeah, so we continue it just to have a quick little note.
Yep, go for it.
Several came before me as a judge, actually, and all from the same court. And what puzzled me, and I'm sure if we think about it, the Oranga Tamariki was asking the court to make an order in relation to a subsequent child who may or may not be born, based on the evidence of a child living, but was in respect of whom there had either been, conviction in respect of murder, manslaughter, or infanticide, or more commonly, and those are the only ones that came before me, there had been care and protection issues, orders made, and there was a possibility that they might never be returned. It's draconian because it's such a powerful tool in the hands of the state, and I've heard that there's.
Can you pause it?
It's an application before the court, but most of these fund.
Now there is an interesting fact.
Right.
The one that came, where she mentioned about the fact that the children may not be returned home.
Yeah, but
however,
she was going on about manslaughter and infanticide and stuff, but then she says, but more what I deal with is just care and protection concerns.
Yep.
So what's
the problem
the child got to go for then?
So what they base that on is the one child's already been uplifted. The chances of mum and dad having changed their ways is pretty remote. And even if you've done all of the courses and everything like that they want you to do, that's still not sufficient enough, because you already did this to one child, is what they are claiming. So when they put it forward under 18A, that child is not going to return home because they've been uplifted and they've gone under a 101. So therefore, what they try to say is the next child needs to go into care because mum and dad are going to do the same thing to the next child.
So they've got extrasensory perception now and can foretell the future.
Well, yeah, and that is very wrong to be doing that to anybody.
Isn't
because
it?
At the end of the day, those cases that come before them,
restraint.
well, exactly, and it's okay. It's also arbitrary interference.
Yeah, yeah.
So yeah, I just thought I'd get you to stop it there because yeah, that to me, when they say that is to me it's annoying to hear, because when they say that the child may not return home, what they do not tell any parent is that under section 1371D, if issues arise from the plan put before the court, then the plan under section 128 isn't adequate or appropriate, because if there is an issue arising from it, and you raise it, so 1371D requires any person to appear before the court if there's any issues arising out of the plan. Okay, so if you get the plan and that plan says there is no realistic possibility of return home to your child, your first option is you say to the court, I have issues with the plan. Then under the 128 plan, then under section 130, because the court's got to look at section 130 contents of the plan, and the contents of the plan have to be adequate and appropriate. So if there's issues arising from the plan cannot be adequate or appropriate. Even though the court may go, yes, it is adequate and appropriate as far as they are concerned, the issue that arises from it is, I do not agree with my child not being returned to me.
Yeah, that's not a good plan.
And so if under 130, the 128 is a prerequisite to, or comes before, getting a 101. So if you are saying that there is issues arising from that plan, the 101 can't be granted or shouldn't be granted, because it's a prerequisite that the plan has to be sufficient and appropriate and adequate.
It says even here, in accordance with section 130, right there.
That's right, but parents don't know that. So like the first, like I say, the first thing you want to do if they're turning around and saying in the 186 report is an interesting one too, because they pair up the 186 report and the 128. But when you go into 186, a report by social worker, right?
Yeah.
These social workers, if you look at the
bullshit story, but yeah, carry on.
So subsection 2A, right? It sets out the plan for the parent, guardian, or person who's having care, or person who had care, that wants the return of the child. Now, what happens is they turn around, and if you're living at home with mum and dad, or you're living with auntie and uncle, they will give auntie and uncle tasks that they've got to do. 2A says they are not the ones asking for the return of the child, therefore they cannot be expected to participate within the report or the plan.
Of course not. They'd be like expecting your flatmates to be
That's right, but you see, the response we got in regards to that in one of the paperworks was, no, it's not noted, and yes, it does say that. However, families are always put in the 128 plans and the 186 report. Yes, but that's a procedural step error. So therefore, you're expecting someone that is not wanting to be able to get the child returned to them just because they are known by association to participate in a plan that is not supposed to include them.
Right, right.
And so what that does, what they're actually like, for me, I view it as this: when they do that to other family members, whether it be auntie, uncle, nana, granddad, okay, what they're doing is they're including more people in the plan, because the more people that are in the plan, the less likely the objectives and tasks are to be fulfilled.
Yeah,
so even if mum or dad have fulfilled their tasks and obligations, if the other people in the plan haven't done it, the plan still has to be continued for another 6 months if the child is under 7, or a year if they're over 7.
So they're stacking the deck against the parents.
Yeah, so they're making it so that instead of just mum or dad or mum and dad that want return of the child, everybody that associates with them has a part in that plan. Now that's all right if the child is at risk, okay. But if you for instance, you could be living with an auntie or uncle, and the auntie and uncle don't have any involvement with the child, and you're just boarding there.
Yeah.
But because you live with them, they expect them to do tasks in that as well and make sure that, okay, they have to check them out to make sure they're safe to be around. But 182A says no, they don't.
Yeah, that's unreasonable.
Yeah, I raised that in the court myself, and even the OT lawyer at the time told the social worker, yeah, he's right.
Yeah.
And I was asked by the judge which parts of the plan I was talking about, and my answer was everything that involves myself and my partner, because we cannot be included in that plan as we are not seeking the return of the child.
Yeah, you don't care if it comes back or not.
Well,
it keeps continuing. She can get her fucking ass out anyway. Yeah.
Well, I mean, when it comes down to it, it's just one of those things that people should know, because people get put in the plan and they think to themselves, well, what if they don't do their tasks? I'm not going to get my child back. 1862A says have them removed from it.
Yeah, yeah, and that can be done with an application, and I'm sure.
Oh, it can be simply done by a memorandum to the court, just stating when you go to your next court date, bring it up. You know, the plan includes these people, and it shouldn't, because they are not seeking return of the child.
Yep. And the judges, as a rule, should read all the memorandums. So.
Oh yeah, but what happens when they do that? Oh my gosh, you know, when you get one that turns around and says there's a certain section that says a certain thing, and then because I know the section number, turn around and say no, that's in regards to a child going and living somewhere else, or being placed somewhere else, then them having to look at it and go, oh no, sorry, I'm wrong, that was 109 instead.
So they correct.
But, you know, it's one of those things where a lot of parents out there, when they go through all of this stuff, they're just not aware of what is going on. And that's understandable, because, you know, you're going through all of the crap to do with OT anyway.
Right.
You carry it on, because she'll talk about the 78, and you'll hear her say about 14 days after the 78. I mean, you want to be able to make sure that your child's not taken into care, not deal with it afterwards.
No, they're so vulnerable. They're not the sort of people that will go and immediately walk out the door and find a lawyer. And there in itself is a problem, because there aren't many legal aid lawyers that will take these cases up now. So that's an issue. They don't have transport. They don't have phones. So it's a real mission to even, you know, look at it. So they don't look at it. Not one of the ones that came before me was answered by parents. It was just completely an application by Oranga Tamariki. It's also very paternalistic, because we're saying, well, we know what's best for you. We know what's best for you. And also the issues of natural justice. How can it be that it's based on previous evidence only, not the circumstances before?
Oh, did she say evidence?
It's that, and the fact that a little bit further back, she said not that of all the cases that came before her, that a lot of the parents didn't bother responding.
None of them did. They were all applications by Oranga Tamariki, and the parents.
That's right. But the reason there's no response is they were made without notice, and the parents are unaware that they have 5 working days to make a notice of intention to appear. Otherwise, it goes in favour of the other party. And so because they don't know that, the next hearing is held 5 to 7 days later maximum, and therefore granted the 78.
Yep, yep. Just because parents don't know that they only have a certain length of time to put that application to appear.
But yeah, she wasn't making that part very obvious. So
no.
Presently before the court, or relating to the child about to be born. And
you just want to slap the one sitting next to her, because she looks like she's almost asleep at this point, but carrying on.
The other part there that is interesting is the fact that, see how she's saying relating to the child being born, and she was talking about the child being born, okay? An interesting thing to note is when they get, the interesting one was up at Waiparera Hospital, I think it was, with John Tamahere. The mother there, they had an uplift order for the unborn baby. but it actually stated on the order unborn baby and the surname. So that one was dealt with by the people at Te Moananui. They registered the baby under their sovereignty.
Yeah.
But the other way of having dealt with it is that the order says unborn baby and then the surname, right? So the easy way outside of that order and making it null and void is name the child.
That and give birth, because then it's no longer unborn.
That, and also the fact that when the child is born, don't name them with the first and middle name. Give them the initials of the names that you plan to give them, because then you are making them just the person and not the living being.
Yeah, yeah.
And so therefore, by using the first initials, like in law, you've got to use first and last name. So if you don't use first and last name and you use the initials and then the surname, that's not that person.
Just like judges do every
Just
time.
like the judges do, yeah. Although I've got to admit, I've come across one justice in the High Court who uses the full name when the judgments come out.
I think I had that with Kevin Glubb once too. When in the district court, he had disallowed my application to record in the court hearing. Like it stopped me anyway.
Exactly, yeah. But, you know, I just thought I would point that out because, you know, there's these certain things that happen within the court process that, unless you're told, nobody knows about.
That's right, eh? And what would be helpful for fucking families dealing with this crap is some sort of guidance like this out there for the general public or those needing it to get it.
Exactly.
Where's Whānau Ora out there helping them with that sort of carry on? No.
Well, it's like one of the people that I'm helping, and I turn around and said to him, okay, OT will turn around and they will file for a 101. And he goes, yeah. So what you need to do is you need to go and file for custody of the child under Care of Children Act. He goes, yeah. So once they file, they won't be able to do it without notice because there's already a substantive application before the court. Okay, and everyone was saying to me, no, that's not right, it still goes through. Well, he is living proof of the fact that he made the S48 application before they made the S101 application, and the judge put their application on notice, awaiting a psychological report, but no custody to them. You know, so as I said to him, that will stop that happening because there's already a substantive application before the court. And when there's a substantive application before the court, an ex parte application doesn't take precedence over it unless the child is in need of care and protection. But when you get children that are uplifted under, not uplifted, but under the Care of Children Act, Section 31, the court can become a guardian of the child. And this is another tactic that OT are using to be able to get the application for the S31. And then once they do that, they are then able to convince the court that it's best that the child come under care of 78.
Section what of Care of Children?
Section 31, application to the court.
Oh, yeah.
So they can make an application for the court to become a guardian.
Okay.
And once the court becomes a guardian under Section 31.
You can also apply for like your church and Salvation Army and
that's right. Yes, yeah. Iwi, any cultural social service. There's a lot of them.
Yeah,
there is a lot of them. There is a lot of them listed, and what people don't realise is that any person can apply to be able to get custody or guardianship. All it requires is that the court has to have the consent of the person before granting the order. But you see, what happens is, like even with us, okay, we're doing a 101, but 101E of the OT Act says that anybody can apply for that order. All you have to do is consent to it. So if you go down to E, any other person, right?
Yep.
And then it says down the bottom, the court shall not, number 3, the court shall not make an order under subsection 1 placing any child or young person in the custody of any other person other than the chief executive unless that person consents to the making of that order.
So you just got to consent to it.
So you just got to go, I'll look after the child and that's fine. You can have the custody. The silly thing about it is how parents get, like under the Care of Children Act, okay, you've got the Section 48 where you get custody, and then you get 48.1 gives you custody, 48.2 is contact for the parent. And that's under that act, but the is that the Care of Children Act?
Oh, sorry, Care of Children.
Yep.
Just a moment. 48.
48, yep. 48.1, yep. And so 48.1 is in regards to getting the parenting order. Okay, 48.2 gives you, yeah, see 48.2 gives you the day-to-day care, and sorry, 48.3 is the contact. Now in there, it's the court that manages that and puts an order in place.
Okay.
If you're under OT, the OT Act, and you go to the 101, and you're one of the, and you've gone for the additional guardianship, the guardianship under 110. The interesting thing about the OT Act is this: the OT Act, it's not the court that decides how the contact goes, unless the person that wants the contact applies under 121. So the contact with a child is like with OT, they manage the contact, and the courts will always tell you, I can't intervene in regards to contact. I don't have the jurisdiction. The reason they don't have jurisdiction is because the person who's wanted the contact did not apply under 121 to have the court listen to their case and grant the contact. But if you're a parent, and this sounds really bad the way I'm going to put it, if you're a parent and you go for a 101E, and you get granted a 101E, that is a way in which you can manage the contact yourself rather than having the court do it under the Care of Children Act.
So just go for custody, and
and then if you're doing that in the guardianship, they're also going to give additional guardianship to the other parent, because your parents are guardians anyway. But at the end of the day, the 101 gives you the right to decide how the contact happens, unless the other person applies for an actual contact order. Whereas that's under the Care of Children Act, that's all decided by the court. So you will put forward how you want the contact to happen. The court will then take into consideration both parties' things. Well, that's what they're supposed to do, remain impartial. But under 101, that's why so many families have so many problems getting to see their children, because OT gets to decide when and if that contact happens. Because so if a parent goes under, it sounds really strange, but if a parent applies under 101E and says, I want a custody order under that, and they get granted it, then they decide how that contact goes. So if you've got a parent, the other parent that's violent to your children, you can just go, no, you're not seeing them. And there's nothing the court can do about it unless they apply under 121 to get that contact.
Mm-hmm.
So it's a way where, like I've dealt with some of these ones where they've had ex-partners that are on protection orders, but the court doesn't pay attention to the protection order. So
what's the point of them then?
Well, that's just it. You see, there's people out there that do have the protection orders against them. However, the same judge that gives the protection order then gives the contact order under the Care of Children. So it's like, what was the point in giving the protection order when you know that child gets hurt by that parent?
Well, so then you can have like a third person or a supervised access, and then you've got a whole other company that can make a lot of money providing the supervised access, so they can bleed more out. That's
providing they stick with the supervised access.
Yeah, granted.
And a lot of the judges go, no, I'm sorry, that's not needed.
Yeah.
So it's an interesting one. We'll go back to that video. She'll talk about the 78.
To the child about to be born, and when I was being appointed the commissioner, this is one of my little issues that I was going to try and drive, but I was pleased to find out when I got into the office it was already done, and indeed Te Kukuro Te Manawa had actually spoken to parents who had suffered at the hands of this law. And there is a quote, that first quote that's in the submissions, where the mother talks about her whole pregnancy was pretty good. She was trying really hard to do everything right by cis, and it wasn't until she was in labour that she realised there was an order there to take her child away. I mean, how devastating is that? So, and it's so discretionary. It's up to the social worker, and perhaps good social work practice would try and find other ways, but we're leaving it up to a very subjective assessment, and I think that in itself is dangerous. The real...
It is not subjective to the social worker. The social worker must put it through their supervisor, and then the site manager of the actual site then has to go to the national manager, regional national manager, and get sign off on it before it goes to the court. That was one of the prerequisites of the Granny Moss era in 2019 when the Hastings case happened, that all of that had to change. The problem, none of them pay attention to it.
No.
You asked them to see, like we asked to see, the sign off by the social worker, the sign off by the supervisor, the sign off by the site manager, and then the national manager.
And you won't
We
see.
got when we put our complaint in, and they finally came back with the complaint 18 months later. They agreed that the site manager was the one who was. It was noted on the system that all complaints come to him to deal with, and not the national managing office, and therefore he was intervening within them. So where she's saying the social worker signs off on it, okay, that's, yes, the social worker does sign off on it, but what she's failing to mention is the social worker cannot file it because she's not the lawyer. He or she is not the lawyer.
Yeah.
So therefore it's got to go from the social worker to the supervisor to be signed off, then to the site manager, and it's supposed to have national office sign off. Doesn't happen.
So
and
there's
then go to the actual lawyer.
Steps that old child commissioner there completely missed. She's only talking about step 1, not 2, 3, and 4.
Well, yeah, and considering the fact that she's saying it's dangerous in itself, it's also dangerous not to let people know what the full process is supposed to be, but doesn't happen.
Yeah. Correct.
And the fact is, like I said, the social worker can't file the paperwork. It's got to be the council for OT.
Yeah.
Yeah.
Okay. Play away.
Issue 2 for me though, now, and of course this law came in before Section 7AA came into force, but Section 7AA now means, in my opinion, that this law actually flies completely in the face of it, and desperately conflicts with it. So if we look at Section 7AA to subsection 2, subsection B, it says that the Chief Executive, Oranga Tamariki, must ensure that the policies, practices and services of the department have regard to mana tamaiti and whakapapa of Māori children and young persons and the whanaungatanga responsibilities of their whānau kapu and iwi. So how can taking this sort of application to court sit with that? It doesn't in my submission. So what's really important to whānau is that they are supported, and that came through really clearly and strongly too in the Te Kakua Te Manawa report. And as I say, my experience as a judge and a lawyer, it just always pointed to that we needed to wrap very intensive services around our most vulnerable whānau at a time when they really needed it, and that's going to benefit our mokopuna. So those are my submissions in short. I also speak as a mother. Imagine the devastation of having your child taken from you, because every single mother that I ever met, every single whānau that I ever met in my journey.
So how she was talking about 7AA and the whanaungatanga and everything like that.
Yeah.
What she's also failed to mention is 51B4 says exactly the same thing and has been in there the whole time of the Act.
Does she not know that one?
So 51B4, I'm pretty sure it's 51B4, I'll go back to it again. 51B4, yes, recognising the whanaungatanga, whakapapa and the iwi responsibilities within the family group. So it's exactly the same thing, but to state that that 7AA has implemented this is incorrect because it's been in place since 1968.
Yeah, they just need it clarified in a fancy new
It's
one.
a case of let's put it in there to make it sound like we listen to the Waitangi Tribunal.
Yeah. Smoking.
Yeah, but it's always been there. And for clarification of that, it's also in the Care of Children Act. So the care, so the reality of it is 7AA isn't really doing anything special because it's already contained within both acts, and I'm pretty sure both. It's either 5(1)(b)(4) in the Oranga Tamariki Act, and in the Care of Children Act, I'm pretty sure it's in either 5 or 6.
Hang on. We'll see how good your brain is. 5(1)(b)(4).
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 Exact same thing as she just read out in 7AA.
Yep.
So this is, and if you go down to the bottom of it, you'll see that it's been in there for yonks. It's not a new thing. It has been there the whole time. These are the things that they're supposed. 1974. There you go. So it's been in place for the whole time, but they chose to. They just choose not to acknowledge the fact that it's there. You do get some good social workers. I mean, like we had one when we were like within the family back years ago, and he did follow the legislation. And when you get social workers that follow the legislation, it's a lot easier to deal with it.
Where is it? Care of Children?
It should be around Section 5, Section 6 from memory. It'll be principles related to the children's welfare and best interest. I can't remember the subsection, but it's in the same thing. Where are we? Down there, E.
Yeah.
Exactly the same thing, just put in a different way.
Yeah, they're just they're fucking just rearranging the fucking deck chairs, aren't they?
That's all they're doing. Is like they're trying to make it look like, okay, we implemented 7AA, and this will make a big difference for the Māori children. So why didn't it make a big difference under 5(1)(b)(4) then?
Wow. Probably they didn't make a song and dance. Now they've made a song and dance about 7AA. You never know. They might just rewrite the whole act just section by section over long periods of time to make it look like they're actually doing something.
True, and then again, pigs might fly. Oh, hold on a minute. They did over the Wellington
They've
protest.
got helicopters. Yeah, bastards.
Yeah.
Not.
No, I just thought I would mention that because of the fact that, okay, it's clearly within both acts, and it's not like just because they implemented it back in 2019, it's been in there well before that. They just chose not to implement it.
Yeah.
Except for those who are aware of it.
Been in there for 45 years before 2019.
Yeah, exactly.
All right, we'll go back to here.
Yep.
Get my little thing. There we go.
And a judge wanted their child. They just needed help. So I will now, of course, there is the fact of we would like the whole section repealed of 18D. I know that may seem odd, but there's already a very, very powerful tools within the law to take to uplift children who are who may be at risk of safety, and that's section 39, 40, section 78, and it's a very powerful weapon. It's used every day in the courts across the land. You can get an order under section 78 in a matter of hours.
Really?
Like I said, section 71 says you do not require evidence.
Yeah. But they can't do the 128 order or the 101 order until they've had the family group conference. So
the section 78, well, realistically, what the process is supposed to be this is my understanding of the process. A FGC is called, it's decided whether there's care or protection or not. Okay, if it's agreed there is care and protection, okay, in the time you are talking in that room, they are applying for the 78.
Yeah.
Okay. So, and then it will go, but it has to go on notice. It can't be without notice because the whānau just agreed to there being care and protection concerns. If they don't agree there's care and protection concerns, okay, what they're doing is going and applying for that section 78 anyway,
notice.
Without you actually knowing. Okay, and so what I have said to people is, if it's up to the individual what their decision is. But if you are saying, no, there is no care and protection concerns, the first thing you should be doing is checking after you've left that FGC with the courts, has a without notice application been made? If they've made an on notice application, file a notice of intention to appear immediately.
Yeah, because you've only got 5 days to do so. That's
right. And like I say, people leave the FGCs not knowing that, and then all of a sudden they've got them on their doorstep to uplift the child.
Oh, mate, they wait a week for the lawyer to get back to them. And by then it's too late.
Yeah, well, and that's exactly right. But you see, what people aren't aware of is when they come with those warrants, especially if it's a place of safety warrant, the Section 39, 40 and 41 warrants, or 42 warrants, they're all very similar in the fact that they state, especially on Section 39, it states there that if they come to your place to be able to uplift the child, they must search for the child. And then there's a subsection B in there that says that if the person who is executing the warrant believes beyond reasonable doubt that the child is in danger and in need of care and protection, then they can proceed and uplift the child. So number 39 there. So if you scroll down a bit, see how it's got the 3B. If the person believes on reasonable grounds that the child or young person has suffered, is likely to suffer ill treatment, serious neglect, or serious deprivation, then they can remove and detain them. So a place of safety warrant, what it means is, if the police come along or a social worker comes along to your house and a child's asleep, you need to be able to then determine what danger that child is in. If the child is sitting in a lounge and they're sitting in the home quite happily playing, explain the danger and the reason you're uplifting.
Yeah.
It's not a warrant to go and just take a child. It's a warrant to go and have a look for the child, make sure that the child is safe. If the child is safe, exit the premises and go away.
So basically, it's a risk assessment.
That's right. It's like how you would ask the police to go around and check that do a safety check.
Yeah,
that's basically what it is.
Call of concern.
Yeah, but the important part of it is, yes, they can enter, but if they find the child and the child's in no danger, there is no reason for uplift.
Yeah. Wow. All right, shall we go back to this?
Yep.
Yeah.
But what it means, what it's good for our mokopuna and whānau is that the evidence is looked at, not just the past evidence, but the evidence before the court right now.
No, it's not.
There's an independent assessment, and that must be good.
What fucking evidence?
Well, she's saying past evidence. Now, here's the interesting thing about past evidence.
It can be done without proof. So what fucking evidence?
When she's saying past evidence, what she's taking into account there is that you had a hearing. Once you've had a hearing, once you've had a hearing, from that point backwards, you can tell the court that's no longer admissible. It's already been determined.
So they can't keep using that.
No, so that's what I'm saying is when it comes to subsequent child, what's happening with the last child is irrelevant to the next child.
Yeah, well, every matter is decided by its own individual merits.
Yes, but they don't do that in family law. What they do is they go and go, well, the last child was suffering from this, so this one must be going to suffer from that. But because there's already been a determination and you've got a judgment, from there backwards is no longer admissible.
Exactly.
And here's what the court will turn around and do. When you raise that about what's happened in the past, sorry, that's already been determined. We know we are no longer looking at that. We are now going from there forward. However, OT raise it, and hello, we can go back 3 generations.
Oh, I'm sure they will.
Yeah.
Crazy. Just this double
standards completely.
Double standards, double tier fucking system they've got going on. And yet they're supposed to be treated equally.
Exactly, yeah. No equal there.
Yeah.
So I have, sorry, I should have, very rude of me, I should have introduced Te Awa Puputapu, who's our Chief Principal Māori Advisor, and she was instrumental in preparing Te Kupu o Te Manawa. So I just wondered, before we have any questions, whether you've got anything to add, Te Awa?
Yeah, okay. No, I think judges summed it up really well, and I just thinking back to Te Kupu o Te Manawa, I think that's something that stayed with me and many of the team for a long time, is that the the situations that the mama and whānau were in at the time, whilst not ideal, and they absolutely recognised that, they still loved their children, and they wanted their children, and they were doing their utmost best to make themselves and put themselves in a better situation so that they can actually still have their children and get their children back. So and that's the thing that sticks with me, and the fear of when you have a child and knowing that Oranga Tamariki or the state's going to come in without that opportunity to prove yourself was quite striking.
The opportunity to prove yourself does exist. Section
Right.
91 and 92 give you interim, or give you, if they've got it at section 91 and 92, that is just a support order. So you can get an interim support order or a support order. So they can support the whānau. Okay. And the other section that applies, 105(1)(c). So when you look at 105(1)(c), it quite clearly says that the chief executive can delegate where the child lives and manage it from that perspective. There is the opportunity for the parent to be able to, yeah, that's right, but it gives that opportunity for the parent to prove themselves and show they do have the ability to care for the child. So for them to state they don't have that ability, 105(1)(c) says it's there.
Yep. The lunatics are running the asylum, Brent.
Yep, exactly.
And would often create the situation for whānau to either one, ask for help early but not get that, or two, go into hiding. So that was quite traumatic, and that will always stick with me. So I absolutely support what Judge has been saying in the repeal of this section.
Kia ora kōrua, thank you for those words. We've got 2 questions, one from Karen, one from Anahila. Thank you.
Hi, thank you for your time. It was just around that 18B section that you were saying you just wanted to strike off, and you made comments about how section 78s can be used. My concern is that that section has had a lot of disapproval and a lot of people saying that it's been abused. So are you saying you prefer section 78s?
Yes, I do, because it's. I know it had a lot of disapproval coming out of the Hastings case, but it's been around ever since I've been a lawyer under different guises, and I myself have run across paddocks to get into court quickly to file documents under not care and protection, but other situations. What it is, it's not just section 78. There's also a family court rule that allows the application to be made without notice. So that's why it's made without notice to the other side. A little bit like, get the order now because the child is at risk, or there's a safety issue or a hardship issue, and then ask questions later, and then there's a process that follows through. It is actually, there is a lot of law around it, Minister, and it is very, has come under criticism, but it's tried and true, and works, and orders are still made every day under that order. It's probably the process that follows subsequently that isn't always carried through. So, for example, just from memory, I think there's
no, pause. It is not the process that follows.
God.
What it is there's the section 78 that she's not explaining is the minute you have an interim order, the only order that can be gotten after that, if they are successful, is a 101. Everybody knows a 101 as home for life.
Yeah, but even though it's not.
It's not home for life, as I said, 1371D, issues arising from that plan when they say that there's no return. But where she's saying that you are able to basically counteract it afterwards, sorry, but that's not the case. Because once OT obtain any order, it's very hard to get out from under OT in any way. And the procedural steps are not followed by the social workers, and in my experience, certainly not followed by the judges. And so if the procedural steps are not followed under the legislation, how can there be any hope of getting the child back? So what she's stating to me is an unfair statement and an incorrect statement, because I mean, I've been helping a person who's been fighting OT for 10 years.
Yeah.
There are people out there 12, 15 years. You know, a lot of these people, it starts with a 78.
Look at Steph. She had 5 years without her kids and not even one hearing.
Yep. And you see, the reason they don't get the hearings is because they don't know what the process is. I mean, we didn't know the process either, but, you know, the only way you can find out is by looking through the 490 odd sections in their act to be able to, you know, work out what are your rights and how do you proceed. But what she is stating to me is completely incorrect, because the minute a 78 is granted, like 78, it's a 78-1. So once a 78-1 interim custody is granted, the likelihood of you being able to get the child back is very, very small. And the reason for that, once again, no evidence was required to uplift the child.
Yeah, don't need proof.
The judges honestly do not look at the evidence. And if your hearing takes 4 years, the day you go in and your lawyer starts asking for your evidence to be given to the other people that have been cross-examined, that is the day the judge is seeing your evidence.
For the first time.
Before that, there is nothing going in there. The judge is not reading it.
That's disgusting. It really is.
Yeah.
Oh, play on.
Within 14 days. Most times doesn't happen. It should happen. It must.
Meant to be an FBC. Okay, we'll call it FGC.
Yes, but hold on a minute. The fact of what she's saying, meant to be within 14 days, it doesn't happen. It should happen. So why doesn't the judge direct it happen then?
Yeah. Does she not have power as a judge when she was?
Yes, they have the power as a judge under, from memory, it's either 29 or 30 of the Act, of the OT Act, to be able to direct that the family coordinator for the FGC organises it and has it. It can be directed by the court.
Yeah, yeah. And then, of course, along comes COVID. And
yes, but there's no excuse on that now because we've got Zoom. Hello, Robert.
I agree. They're using it.
Exactly,
We're
yeah.
using it. You know?
Yep.
Moving on.
Yep.
So if the process was followed, and the idea is to bring the whānau together, get them to talk.
If the process was followed. It should.
Well, I will say the process gets followed in an FGC, but you have to follow the procedural steps and not the process, because the principles and policy that they operate under is not legislation.
Yeah. Yeah.
So what she's talking about is the fact that Oranga Tamariki have their own policies and how they deal with their FGCs. However, those policies are not legislation. And they are not the procedural steps that need to be followed.
No, but they base their policies on the legislation. Like the COVID.
Well, if you read them, no, they don't.
Yeah. Like that COVID policy. You know, there's 200 odd OT workers at the moment wondering if they're going to get canned on the 1st of April. You know?
Yeah.
So we'll see.
So yeah, their policies are completely different to the legislation, and they don't follow the procedural steps in it.
So one of my golden rules: policy is not legislation.
Exactly.
Try and sort this issue out and make sure that their mokotuna, their taonga is safe and loved, and you know, I mean, identity is a huge issue, isn't it? And so if we don't have to take our babies away from their whānau, then let's not. There will be times maybe.
Take our babies? What is this? It takes a community to raise a village type fucking speech shit.
Yep, but what she's failing to acknowledge there is, okay, nobody asked them to arbitrarily interfere in the first place.
Exactly right.
Maybe that's necessary, but I would say they'd be extremely, extremely rare, because if we put the right supports in place right at the beginning, I think it would do wonders. Yeah.
It would require a social worker to do their job correctly to do
We're
that.
talking about two really negative situations for the whānau under Section 78 and Section 18, and it's a really hard outcome.
You mean 18A?
That's what Judge is saying, and what we also heard in Te Kukuti Mana was the absolute responsibility for that process to be right. The process right from the outset and the process following, as Judge is saying, is quite quite important, yeah.
And sorry, if I could, thanks, Tiara, if I could just add in there that the issue actually with Section 18B is that it's an on-notice application, so it takes months and months and months. And of course, the whānau get that they usually don't engage, they don't realise how important it is, they don't get legal advice. Whereas a Section 78, they focus.
Again, false information, because Section 18B and 18A are ex parte orders without notice.
Yeah. Exactly.
Yeah. So where she's saying that they're on notice, no, they're not. That's what the family court rules say, is that if it's an urgent case, an ex parte application can be made without notice. So when they turn around and they know, like, these social workers literally contact the hospital and find out, has the mother come in to be able to, into the birthing unit. Once they find that out and they realise they're there, they're giving birth, they file an ex parte application to be able to get custody of the child, and then they come in and take the child. That's what happened with the Hastings case.
Yep.
And the social workers got caught out because the judge had been told, and it was on the video, the judge had been told and granted the order, we have the child in our custody.
Yeah,
Yet the child was in the mother's hands.
They never ever got that kid.
Yeah, exactly.
It's happening. Orders, so everybody focuses. I think it's better for mokopuna.
Since when do you give a toss about
We
mokopuna?
are actually now out of time, and unfortunately, my apologies, Anahela, we've run to time now. Thank you both for coming before us. We probably will put some questions in writing to you, so that we can manage to get through that. But thank you for the work that you do.
I think that's pretty much the end of it, nearly.
Yeah. Don't need to hear them polish each other's fucking little breastplates or whatever.
Yeah, exactly, yeah. But yeah, as you can see from that, I mean, you know, they're talking about with the protesters spreading misinformation. There it is there.
Yeah. From the one source of truth.
Exactly. And the worst part about it to me is it's from a judge.
Yeah. And now the child commissioner.
Yeah, and so if the person who's dealt with this sort of thing for a career.
Oh, but don't forget, she's a mother. She's a mother as well.
There's another word that comes after that.
We'll keep it clean.
Yep. But it's just one of those things where you look at the situations, and when you hear stuff like that, you can see why we've had generations of parents going through this.
Oh, for sure, mate. For sure.
Yeah.
Follow on. Well, we've been going for almost 2 hours, bro.
Yeah, that wouldn't surprise me.
Yeah. It's not
But
hard.
yeah, no, like I said, I'm still going to read through that rest of the other document, but it's a very, very interesting read. The first 23 pages. Very
sure you're going to take some bullet points, and I'll be.
What I'm doing is I'm taking the parts that I find useful, and I'm putting them into. Well, I put them into a Word document. Now I've just created them on a Google Doc because, as the missus and daughter said, yeah, but you forget to save it on Word. So, so I put it into the Google Doc like they said because it automatically saves to the drive.
Yeah, it does. Yeah. No, that's cool. All right, bro. Well, I'm going to call it a night, and
Yep.
have a good one. We'll catch up again and talk about the rest of what you've read afterwards.
Yep. I'll send you a copy of the complaint so you can have a good read.
Oh yes, please. Always love to
Yeah.
hear. Always love to hear good things that are going to happen to Timmy. Love it.
Yeah. Exactly. Yeah.
Yes,
Okay, man. Well, you have a good night.
We're talking about you, Judge Black. I hope you like being on social media, you stupid old bastard. Anyway.
Oh gosh.
Gotta have some
Okay,
fun.
well, we'll talk again soon. But yeah, I'm amazed at all of the misinformation in that video.
Yeah, that's unbelievable for a child commissioner and family court judge. Not to mention a mother, you know, knowing all that.
Oh, exactly. Yeah.
Cool.
Okay.
Have a good
Good. See ya.
Thanks.